Welcome to Shenkman Education. My name is Marty Shenkman. The topic of this video clip is the duties and responsibilities of a trustee. A trustee is a person appointed in a fiduciary capacity. That means a position of trust. There's another video clip on that. To manage a trust, which is a legal agreement or contract that you, the person setting it up, create with the trustee. And in a revocable trust, you might be the first initial trustee, but you should name successors. In other trusts, there's going to be somebody usually other than yourself, almost always, especially if it's an irrevocable trust done for asset protection or tax planning. An irrevocable trust will have a separate independent trustee and yourself. In some instances, it can be a spouse or family member. In other instances, it perhaps should be somebody independent. That's a different discussion. What we're going to focus on are the duties and responsibilities of this position of trustee. So again, it's a position that is one of trust. It's a fiduciary. So if you're serving as a trustee, you have to be very careful to carry out your fiduciary duties with the duty of loyalty, care, and all those other legal doctrines that apply to a trustee. First step, if you're a trustee, get a copy of the trust agreement. Make sure you have the complete current trust agreement. Even irrevocable trust, irrevocable meaning can't be changed, can be changed. It's sort of not really an appropriate term to describe it. So you may have a trust that is irrevocable, and whether it's revocable or irrevocable, you could have change in trustees. There's different people that could be given a whole array of different powers in a trust document. You got to find out if any of those have been exercised. Has the trustee been changed before you got to be trustee? Has the situs, the state where the trust is being administered, been changed? Has someone exercised any of the rights in the trust? Do beneficiaries have withdrawal rights? Have they been exercised? You need to find out what the current legal status is of that trust. That's step one. In the second step, or part of the same step, you need to read all that stuff and understand it. My personal way of going through it, and everybody will have a different way, I like to get a PDF of all the trust documents, compile them into one document, convert them to Word where I can annotate them, and I highlight key trust provisions in yellow and write notes and comments or questions to follow up on in green highlight. I just like the visual of that. Everyone's going to have a different way of doing it. A lot of times lawyers, when they review a trust, they'll write a separate memo. I like the comments and highlights right in the body of the document because then you see it excuse me, in context, and I think it's easier and simpler to keep your mind around all the different things that you're dealing with. So make sure you understand the document. The trust document in its current form is the Bible. It governs, it's the roadmap of everything you're going to have to do. You must get your arms around that. Second, at some point in the trust process, and fairly early on, have an estate planning attorney. Not you yourself if you're not an estate specialist. Even if you're a lawyer, get an estate specialist. Review the trust with the input from the investment advisor and accountant. Are there things in that trust, even if it's irrevocable, that would be helpful to modify? Very often you can make modifications in the trust to the trust document, or even just merely the administration of the trust or the assets of the trust, and reduce or even avoid state income tax. Another topic, but don't assume that whatever that governing document is, with all the different pieces we talked about, is the final result. You may be able to improve it, and you may have a responsibility. I'm not going to specify clearly that, but you may have a responsibility as a trustee that if you can make simple changes and save state income taxes or other things, that you probably need to do it. So now you got your arms around the trust. You've had an attorney review it to see what, if anything, can be changed. You need to gather assets and make sure you have knowledge of and control over all the assets. Now, sometimes that's easy in the sense that there's a trust brokerage or bank account. Fine, make sure you're listed as the trustee. And by the way, you may want to file Form 56 with the IRS notifying them you're the new trustee so you get all notices. In terms of identifying assets, it could be much harder. If somebody has real estate in a trust, you're not getting a statement, you got to find the deed. You need to find out if there's business assets like an LLC, a corporation, equity interests of which are owned by the trust. A good place to help identify assets, get the trust income tax return and go through it. If the trust was a grantor trust and a return wasn't filed, that may not really exist, or it may just be a simple statement saying that all the assets are reported on the personal return. In that case, you may want to get the personal tax return of the person who set it up and see what assets or income rather, or deductions are reflected on the return, and use that to backtrack into the assets. You have to manage trust assets. If there's rental property and you don't know anything about rental property, hire a professional real estate broker or management company to manage it if you don't know how to do it. Don't be a hero to keep costs down and find that things are done incorrectly. It's not a help to the beneficiaries, it could be a liability to you. You need to invest marketable securities. You need a proper asset allocation, proper diversification. You need to have a financial plan and have an analysis done showing why you've come up with that allocation. If you're not an investment professional, my suggestion, if you're in a fiduciary capacity where you have this position of trust and responsibilities to beneficiaries and maybe even to the settlor of the trust, I would really hire a professional. I want someone that does this full-time for a living. Professionals are used to documenting the process by which they make asset allocation decisions, investment decisions, sale decisions, and so on and so forth. So look at hiring a professional. You have to maintain books and records. So often when there's families or family members or friends as trustees, they completely ignore this. Don't. Hire an accountant. Even if you keep informal records, you have to keep copies by year of all the financial statements, information on all the assets, the checkbook, even if it's electronic, all the expenses, the tax returns. All that information needs to be maintained so you can prove exactly what was done financially with all the trust assets. Now, a formal accounting is something, and it's going to vary by jurisdiction, where you have to adhere to very strict criteria set out in court rules as to how you record income and expenses and payments, distributions, etc. That's something that is really difficult and very precise and very nuanced, and you should probably hire an accountant or an attorney that's familiar, not generally with that, but in the jurisdiction where the reports will have to be filed if necessary. Now, that's costly, but even if you don't do that, do the middle ground of at least safeguarding all the records. Personally, I would recommend, if there's sufficient funds in the trust, and even if there's not, you probably really want to hire an accountant that's familiar with trust accounting and say, listen, I want to spend a reasonable amount of money. I want to minimize or control the costs, but I want to know that we've kept records properly. And by the way, those records, you should very carefully talk to an attorney in that state and determine what records or reports should be issued each year to beneficiaries. Now, many people opt to do the minimum state law requires or the trust document requires, so you have to look at both state law and the trust. But on the other hand, from a strategic or interpersonal perspective, you may be better off providing even more data to the beneficiaries. That's a decision you really should review with an attorney. My experience has been that in many cases, if you provide reasonable information on an ongoing basis to the beneficiaries, they're less likely to be suspicious of what you're doing, and it's much harder for them to claim that they didn't know what you were doing if you gave good disclosures. So I kind of err on the side of disclosures, and that may be more than state law provides, but that's a decision you as the trustee should make with an attorney. And you really do want to do it formally. So find out what type of accounting. Beneficiaries in some states need to be loud truck. Needs a new muffler. Beneficiaries are often entitled to at least receive a copy of the trust document. Again, understand and know what the minimum is required by the trust, if anything, by state law, but also think practically, what do you do? And some of that may have to do with the status of the beneficiaries. If you have a beneficiary with an addiction issue, maybe you want to give them the minimum by state law. If you have beneficiaries that are fairly sophisticated, maybe you want to give them a lot more information so that they can analyze it, understand it, and if they have an issue, raise it. In some states, if you give appropriate disclosures, and you have to understand what the state law requires, to the beneficiaries, after some really limited period of time statutorily by the state law, they lose the right to bring a claim against you. That's really worth thinking about. So accountings are very important. If there's charitable beneficiaries, see what the requirements are and see if there's any requirements to report or give disclosures to the state attorney general, and the rules on that will vary by state. So serving as a trustee is a very important process. You could be the most critical person to carrying out the wishes of the person who set up the trust, protecting minor children or other beneficiaries, whether with special needs, addiction issues, or just their financial futures in your hands. Take the role seriously. Yes, I understand the need to conserve costs and be mindful of what you spend and how much time it takes, but you want to do things right. Don't skimp on hiring professionals where it can get a better result for everybody and protect you. Please keep in mind that all the information on the video clip is for educational purposes only. Don't take any legal action without consulting appropriate professional advisors. For more information, see shenkmaneducation.com. Thank you.